I wanted to talk a bit about connectivity to multi-dwelling units and multi-business offices. What we're seeing at the moment is that the operators are tending to leave these properties behind in their build, and that's mainly because there may be technical issues, but equally it's so difficult for them to get away leave with the landlord. The landlord typically will have a solicitor acting for them, and obviously that solicitor wants the best for the landlord. But the code, the electronic communications code, is written in such a way that it does help operators. Equally, it helps landlords as well, but there are different interpretations on the code, and one of the things that we as a solicitor for an operator needs to protect is that if an operator has a tenant in the building and we get the wayleave for that tenant to receive services, it shouldn't be mandated, which it usually is by a solicitor for the landlord, for that operator to remove all of the equipment from the building, the common parts of the building, once that tenant stops using the operator's services. Because what happens is we go through the whole process yet again, and further money needs to be paid out by the operator to pay for the freeholders, landlords, solicitor fees, potentially surveyor fees, fire stopping issues, and it just isn't economically beneficial for the operator to do that. We need to look at the telecoms industry, particularly in these MDUs and MBUs, as a long-term strategy for Britain to have the best electronic networks services that's available to such clients.